time and come to section 32 now. This was not shown yesterday.
हेलो फ्रेंड्स, स्वागत है आपका विवेकानंद एकेडमी में। आप लोग जुड़े रहें
This is significant.
और ये सुनवाई चालू हो गई है।
Power to make regulations. The council may, by notification in official gazette, make regulations not inconsistent with the provisions of this act, rules made thereafter.
बिल्कुल, सभी BSTC वालों का स्वागत है, बीएड वालों का भी।
Please come down to 2DE. In that, qualifications of teachers under section 12A.
ये BSTC की तरफ से है भाई ठाकुर साहब, मीनाक्षी अरोड़ा जी है ये, BSTC की तरफ से बोल रहे हैं अभी।
That's the only place where there is a reference to the RTE Act in the proviso.
ये भी जज साहब बैठे हुए हैं।
If I not will just turn back for a moment to 12A.
कपिल सिब्बल जी देखते हैं, फीस तो दी है उनको, देखते हैं सर आज कपिल सिब्बल जी का भी इंतजार रहेगा।
My lords have the second proviso. Provided further that minimum qualification of a teacher referred to in the first proviso shall be acquired within the period specified in this act or under the Right to Children to Free and Compulsory Education Act 2009. So therefore, if you are doing it for the purpose of RTE, then in accordance with RTE, otherwise where it is under this act, the regulation is formulated here. That is somewhere what I think Dr. Singhvi tried to point out, but I am not going on that particular aspect. What I am trying to show here is, what does the NCTE do? It formulates regulations. It includes that regulation for qualification of teachers under section 12A. Now, if my lords may turn over to section 33. Rules and regulations to be laid before Parliament. In the present case, the 2018 amendment has not been laid before the Parliament. Every rule and every regulation.
2018
amendment is not placed before the Parliament. That notification is not placed before the Parliament. And that's one of the things that the High Court has noticed, but High Court didn't dwell on it because it decided on another aspect. It was argued, my lords, the argument that I will make is...
regulation has to be placed before the Parliament.
My lords, after the regulation, I'll point out what happens is that once, that is why I'm...
Is it your case that under the NTC Act,
Yes.
doesn't have power to issue notification?
My lords, once...
What is your argument?
My...
What I'm trying to say.
My lords, my submission is going to be this, that once it regulates in the matters of the eligibility, issues a regulation, that particular part rules and regulations are then laid before the Parliament. And if there is a change that is made by way of a notification, that part of that process is also placed before a Parliament, because this exercise was done with respect to 2010, which is purportedly amended in 2018. In 2014, where a change was carried out, that was placed before the Parliament, and thereafter the notification was issued. Regulation was framed, notification was issued, and that regulation had been placed before the Parliament, thereafter the notification was issued. And my lords, there is a past thing about 2014 notification here to that extent, and 2018 notification, that part, there was no change in the regulation, never placed before the Parliament, only the notification having been issued. My lords, I'll come to that. That is the 2014. And this was before the High Court. I'll just show that. It was a part of the pleading there also. Would my lords please read 33 with me for a minute? Yeah. Every rule and every regulation made under this Act shall be made as soon as may be after it is made before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or two or more successive, and if before the expiry of the session, following session or successive, both houses agree. Now, all that the houses have to agree is to make any modification in the rule or the regulation. Both houses agree that rule or regulation should not be made, or rule or regulation shall thereafter
ठाकुर साहब बिल्कुल समझाते हैं, थोड़ा सा रुको आप।
or be of no effect, as the case may be. So, however, that shall be made without prejudice to validity of anything previously done under that rule or regulation. So it is placed before the Parliament. Parliament may, in its wisdom, choose. Does it want to make any modification?
ठाकुर साहब, मीनाक्षी मैम जज साहब को समझा रहे हैं जो भी नियम्स वगैरह हैं.
As it will be modified, it can recommend back. Otherwise, it will go through the test automatically. But the requirement to place it before the Parliament is provided in section 33. Now, having said this, it is my submission then, the central government through the MHRD would not have passed any kind of a direction as have been presently done by the minister.
MHRD और केंद्र सरकार ने कोई डायरेक्शन नहीं दिया था और एनसीटी ने ऐसे ही रूल्स बना दिए थे.
So my lords, please come now to section 34. After this. Of this act.
यस इंडिया, अच्छी मजाक कर रहे हो यार भाई.
If any difficulty arises in giving effect to the provisions of this act, the central government may by order published in the official gazette make provisions that are not inconsistent with the provisions of this act as may appear to be necessary for removing difficulty. So my lords, what the central government can do is only if there is any inconsistency or difficulty in implementing. It may pass
नरपत सिंह जी, स्वागत आपका. अभी तक ये हुआ है कि बीएसटीसी की तरफ से मीनाक्षी मैम बोल रहे हैं और बता रहे हैं कि भाई ये एनसीटी ने कैसे गलत किया है एसटीसी वालों के साथ. पर्याप्त मात्रा में छात्र अवेलेबल हैं और ऐसे कैसे कानून बना सकती हैं, इसके ऊपर बहस चल रही है अभी. बिल्कुल सर, आर्गुमेंट्स चल रहे हैं अभी.
Central government may, by order published in official gazette, make such provisions not inconsistent with the provisions of this act as may appear to be necessary for removing the difficulty, provided no order shall be made under this section after expiry of 2 years from the commencement of this act. So it is verily believed that if there is any difficulty or any inconsistency,
यस इंडिया,
it will come into force within the period of.
स्वागत है आपका विवेकानंद अकेडमी लड़ा के यूट्यूब चैनल में.
You may pass certain directions and orders, but after 2 years, not under 34 in any case. Now, my lords, let's go back to 29. Having seen 3, formation of an expert body, 12A, council is going to then deliberate.
नीरज कुमार मीणा अभी तक तो नहीं दिख रहे हैं यार. कपिल जी सिब्बल सर.